What's up, guys? Brian Felfel, Law Group PLLC here with your Florida Law Weekly Case Update. It's been a few weeks since I've done one of these videos, but it's good to be back and good to see everybody again. Got 4 cases this week. Let's get right to it. First one, tough case for this person who it has to do with permanent alimony, which we all know is now no longer in effect. But for this poor former wife, she litigated her case for over, I think, 3 years. She goes to a final hearing in front of a general magistrate before the statute changed. She has her whole trial and she puts on all of her evidence for why she's entitled to permanent alimony under the old statute. Trial ends, everybody submits their proposed judgments, and then it takes a few months, I think like 3 or 4 months, for the general magistrate to finally enter her proposed report, and she ultimately awards permanent alimony. But by that time, the statute had already changed. So, unfortunately for a former wife, she's not entitled to permanent alimony, even though she already had her trial. And the issue here was, what does it mean under the statute to apply to cases that are pending, dissolution of marriage cases that are still pending as of the date, the applicable date of the statute? And the court found that pending means basically until there's a final judgment rendered in the case. So unfortunately, she's out of luck and she doesn't get her permanent alimony, even though she probably deserved it. Next case is out of the 4th DCA, has to do with domestic violence. And this has an interesting case, has to do with corporal punishment of children. So in this case, a father had a 14-year-old daughter. He takes her on a vacation to Colorado. They go skiing. They have a great time. They come back, and the daughter gives her father a gift. And the gift is a pair of socks. Turns out the daughter actually didn't purchase those socks, and instead, apparently, she stole the socks. So of course the father gets upset, goes and takes her cell phone. He finds in her bag, I think, some marijuana and a vape pen. And apparently they got into a little tussle, as the trial court described it. And in that tussle, the former husband essentially grabbed the cell phone out of the daughter's hands. The daughter was alleging that he was like punching her and doing some other violence to her, but the evidence at trial really showed that he wasn't really doing that. He was just kind of just grabbing the phone from her. And so the domestic violence court issued an injunction because the daughter was essentially like scared to go back and visit with her father after this incident. Appellate court reversed and said, look, if this is corporal punishment, it's reasonable corporal punishment. It's not excessive. There's no bruises. There's no marks or anything like that on the daughter. And it's just basically one incident of the father getting into a tussle and trying to grab the phone from his daughter and successfully grabbing the phone. And that didn't amount to domestic violence. That's corporal punishment. So good case to reference if you have a client that's engaging in some sort of reasonable corporal punishment. It's probably not going to be enough to get a domestic violence injunction. Next case has to do with quadros, and this case really is another unfortunate scenario for a former wife. She agrees in an MSA to a quadro for her husband's FRS pension plan, and of course, as a lot of us know, a lot of these husbands or wives who are participating in FRS, they can go into DROP, the Deferred Retirement Option Program, where basically you can elect to get a separate account and receive your retirement early while you're still working. And so the question becomes, well, who's entitled to that drop? So what happened here is the quadro that was entered had a line that said that the former wife is not entitled, specifically not entitled to a share of her husband's drop. And the former wife argued, well, I didn't even realize that that was actually in the quadro. And so she tried to set it aside, and she tried to go under 12.540, and she tried to say that this was a clerical mistake. And the trial court basically agreed with her that this was a mistake, and scratched out that language in the quadro saying she's not entitled to the drop. Well, appellate court said, actually, too bad, because just because it's a mistake, it wasn't a clerical mistake. It wasn't like something where you just, you misspelled a word, or you missed a period or something like that. This is a substantive change. And so even though this may have been what the parties intended, because it was also after a year, so she could no longer go under a normal motion for rehearing, it's after a year, she's not able to change the quadro language, so they're stuck with that paragraph in the quadro that makes her not entitled to the drop. So too bad. Last case is another paternity case. I think I've spoken on this before, but interesting, where there's a legal father who's put on the birth certificate, where the parties are not married. He's put on the birth certificate, signs the birth certificate, right? Turns out he's not the biological father. Everybody agrees he's not the biological father. DNA test provides that another man is the biological father. So the biological father filed a motion to intervene in this paternity case to try to disestablish the legal father's paternity. And the appellate court said, nope, can't do that. You don't have standing. The only person who has standing to disestablish their own paternity is the actual person, the legal father, the person who's deemed to be the legal father. And because they signed the birth certificate, 60 days goes by and they don't rescind the birth certificate, that's legal establishment of paternity. And so basically the only way to get around that is to show some sort of fraud in establishing the legal father as the legal father. You can't file a separate motion to disestablish paternity based on the fact that he's not the biological father. You just can't do that. He doesn't have standing. The biological father is basically out of luck in that regard. The only way you can get around that is to file some sort of motion saying that the mom and the dad committed some sort of fraud when they signed the birth certificate. So otherwise, out of luck. So anyway, hope everybody enjoyed that. Can't wait to see you guys again. Take care.